for a long time. There's also how do we then rewrite, the history. This is also part of the playbook. If you really go down in certain spaces, you'll find that there's certain parts of history that are actually erased or rewritten. Are then also naturally, it's polarization. They divide and conquer. Okay, and food is literally the first thing that is the thing, or it's money. We have in spaces where you see that others are being funded for certain things, and some are not. Okay, some are given water, and some are not. Okay, so that then becomes the them versus like us as well. So you also find that they also we have seen an increase in targeted arrests. Okay, this is just for someone liking like a simple post, to say I do not like this government, and they find themselves behind bars for saying the truth or their truth. Okay, but I think the emphasis really with these regimes is like how then do we silence or restrict, the growth of CSOs, and how do we silence, the opposition groups, and so that is the premise of the playbook. But there's also something that then comes after this, and this is like feudalism. Next slide, please. I think those who know the term itself, back in the day, there was a point where people were given land, and you would then say, come on my land, work for me, and that would be like your rent, okay? So literally, you're working for staying on the land, okay? So obviously, it's someone with big money, buy big land, and we don't have anywhere to stay, and we just accept because we actually need somewhere to stay. But for us to then be able to stay there for a number of days, we need to be doing some form of work. And that is the work that can be, we're in the fields, we are plowing, et cetera, et cetera. So it is still a power thing, okay? Where somebody has got power, somebody is controlling the ecosystem, and we are inside it, and we're just trying to comply. So you find that this also is now something that is now defined as techno-feudalism, okay? Which is now big tech type of platforms, as WhatsApp, Meta, the Googles, et cetera, they've actually now built their form of economy, and we are in it. And how are we in it? There has been an issue of dependency. Right now, are you aware that the number one complaint of FIFA this year, currently, do you know what it is? Anyone? Anyone in the crowd? No? None? It's internet access, okay? Everyone is complaining that the internet is slow. Everyone is just saying it's slow, it's slow. Brian is doing the best, Brian is saying, you've got access, guys, okay? Get it. But dependency is the number one thing. And all of us, subconsciously or consciously, we can see that we are dependent on certain issues. So it also is an issue about data control and privacy. I really love this because there is a thing that we also do train and raise awareness of, okay? And it's happening here right now. As we are linked to the Wi-Fi here, my laptop was attempted, to be, in quotes, like hacked, okay? By the hub partners there, to just showcase that people are getting into a platform, but all our traffic is actually being read, okay? Which is the same thing as how then big tech is also like doing it. There's also the issues of inequality and access. I think that is a thing. Then also, when big tech is in a country, it also then kills the issues of the locals. innovation and platforms, like startup. Then obviously, there is the issues of governance and legality, which I think is going to be unpacked by my colleagues. So what is the link, between these two concepts? Simply, there is a link of saying someone has got big power and they have taken the platforms or the ground that we're in, and we are now the product and we are dependent. And at the same time, we actually then don't ask the why. So during my journey as a civic space fellow, we are working to actually just make things seem simple, explaining tech in a non-tech way. Digital literacy is a thing that we actually ain't aware of fully. We've got tech, but are we aware of what is actually happening? That is one. Two, we need to be acknowledging that we are in a repressive digital economy and actively then say, what then do we do? We should not be talking to ourselves in this room. Like now, everyone right now has got a phone, has got a smartphone, etc. But are we the right people to be in this room, or are we then pushing this narrative to the people that actually matter? Because platforms like internet, okay, WhatsApp, etc., are being used by grassroots type of organizations. Governments that are repressive during protests, they then shut down the internet. They then partner with the infrastructure like holder. At some point, if the ecosystem is actually grown, governments can then also say, hey, Meta, we are friends. Please, can you shut this down, okay? I think we're already seeing some form of relationships, especially in the States, where people are now aligning to a certain individual, and it's okay. But is it okay? Because it now means that someone can then have coffee and agree on shutting down a certain platform that we are all using and, in quotes, dependent on. So I think I'll just pause here and pass the baton to someone else.
Thanks, Tawanda. I think we're going to go now to Mercy, and she's going to talk about how we can be designing interventions to counter both tech and state authoritarian practices.
Thank you so much. And I have to say I really enjoyed that presentation because it sets us thinking about tech and tech dominance in a language we're very familiar with, authoritarian governments, which is something that as Africans we've consistently fought. I have just a very short pictorial to show you. So you might not even know any of those people on that picture, but this was the cover of the Daily Nation newspaper. Kenyans understand that's like the biggest newspaper in Kenya. And to your far right, to the top, that's our president. And below him and to the left is the TikTok head and someone else from TikTok. So this was not a meeting that took place during COVID years. This was a meeting that took place way after COVID, when the president had called for an emergency meeting with TikTok because in Kenya, TikTok at that point was being used, the 3 a.m. lives. At 3 a.m., people would go live to do a lot of crazy stuff because Kenyans had figured out how to monetize through TikTok, okay? So when he called for a meeting, the TikTok head could only give him a Zoom call, not a physical meeting. And that ended up being like on the cover page. I'm smiling because I think this is very problematic, but clearly nobody in the room thought it was. And then the next picture, next slide. The next picture is someone you might be familiar with, Nick Clegg, who holds a position at Facebook. That was in 2022, And as you can see from the hashtag, it was the 59th Jamhuri Day celebrations for Kenya. Jamhuri means independence. It was the 59th Independence Day for Kenya, and the chief guest was an official from Facebook, to celebrate independence, who also did not come to the celebration physical. By the way, we are very momentous about these things. Our Independence Days are full festivities, a public holiday. Everybody is on in a stadium. It's a whole celebration. And then there was a Zoom login by a Facebook official who was the chief guest. Okay. I show you those pictures to just set your mind thinking through the relationship between tech companies and our governments. And I'll say more, but just by a way of introduction and contextualizing my perspectives on this, I am a litigator based in Kenya, and over the last 4 years, we've been involved in litigation against Meta. 3 cases in total, 2 cases representing Facebook content moderators who were trafficked from different African countries to Kenya to do Facebook content moderation work. If you're familiar with that work, it's very harmful, inherently harmful. So we represent very young and courageous young Africans whose lives were ruined because of being trafficked and being forced to do this work without any care and protection mechanisms. And then the third case is actually a case we collaborate on with Amnesty and Katiba. Is a case that really focuses on the algorithmic amplification of harm. And the focus here is what happens when Facebook is making so much money in the context of conflict, because in vulnerable situations, people are going online and sharing very inflaming information. A lot of this is going viral, which means Facebook is making a lot of money from this viral content and pushing it even more. And then what happens when that content ends up igniting, facilitating, worsening civil conflict on the ground, as we saw in Ethiopia? That is the focus of that case. Incidentally, it's actually before court this morning. All right. Here are some things that we've witnessed in carrying out this litigation, just against one tech company, by the way. We understand that these tech companies are driven by dominance. That is the end goal. We've had the conversation from the journalism sector and the Google dominance conversation there. We also see the behavior of social media platforms like Facebook, like TikTok. Their goal is to dominate the market, buy out WhatsApp, buy out any other competitor as long as you dominate the market, and do anything to get there. When I say do anything to get there, this is how you get from, we are going to need content moderators. Let's not employ content moderators in a lawful manner. Let's actually deploy a human trafficking pattern. This we've seen with Facebook, we've seen with TikTok, right? In the case of the Ethiopian example, we have had access to the Frances Haugen documents, and I encourage you to have a look at them to just understand the behind the scenes. Frances Haugen was a former employee at Facebook who released documents that showed that Facebook really knew and understood what its algorithm was doing in Ethiopia, the impact of its algorithm. It had been designed to make viral content even more viral, and it couldn't distinguish between viral healthy content and viral inflammatory content. So anything that you said, if you shared hate speech and propaganda for war, the algorithm was going to pick it up and push it forward. And there was one email specifically from Mark Zuckerberg in one of those documents where there was a thread where he'd been told, by the way, our algorithm is designed defectively, that it's going to continue supporting and promoting this conflict. And in the email it said, it doesn't seem worth to pursue what that is, because it was going to be a huge cost to clean up the algorithm or to even demarcate measures for Ethiopia. So they're going to do anything to retain the dominance, and doing anything from a capitalistic sense is how can we extract as much value at very, very little cost. We do want the users in Ethiopia because they are our eyeballs and we need them for advertisers, but we do not want to spend a single shilling cleaning up the platform for them, even if it means that this is going to facilitate conflict on the ground. Third is that they believe that no one can hold them accountable. This is how it's played out in our scenario. We've been in this litigation for 4 years, and none of the cases have actually gone to trial yet. which means for 4 years, we have been arguing one issue, one point in court, which is Facebook saying, you cannot hold us accountable in Kenya. And when they're asked why, he said, because you're an American company, you cannot hold us accountable here. So, but people are getting harmed on the African continent. What do you mean you cannot be sued in the African continent? And that issue has taken so much time. We've gone to the Court of Appeal, and this is across all 3 cases. They have made this same argument. And when the courts have actually attempted to hold them accountable, that like we saw in the content moderator's case, very early on, the court said, you cannot just use people and dump them and leave them with severe PTSD, depression, anxiety. They were given an order to return people to work immediately and to provide them with emergency care. What did Facebook do? Facebook shut down its operations in Kenya and moved to Ghana. So when you attempt to hold them accountable, they will pivot out of that accountability. This we know. And what does that remind you of if you think about the political context of leaders who do not want to be held accountable? And number 4, they seek to protect their interests by collaborating with authoritarian governments. So this we see right from the top. I think we've had a lot of conversations on the AU missing in the room and how a lot of policies coming up from the AU look like very pro-AI and pro-development conversations without paying attention to the harms, the competition concerns, and also the labor concerns. In my argument, that is by design. Governments have realized the power that these social media platforms have from a political sense. What do you mean I could game the algorithm during elections? Why would I be interested in fixing the algorithm if I could game it to skew it in my favor? If you think about the first presidency, the first Trump presidency, and the concerns that were raised about fake news and how fake news can change the democratic will of the people, why would a government be interested in clawing down on that? So what we've seen, and we've seen with Facebook, we've seen this with ChatGPT as well, which algorithm was also trained in Kenya, left a trail of hurting young Africans behind as well, is that they are identifying a public narrative that the government is seeking to deal with, like the issue of poverty, like the issue of internet access, like the issue of what is Sam Altman's language, is expanding human capabilities. Nobody knows in what direction doing what, but getting that public good narrative and saying to the governments, we can help you fix this problem. The reason Nick Clegg was in that independence celebration is because President Ruto had said he's going to create 1 million jobs. And in his speech, it was like, yes, we're going to partner with the government to create 1 million jobs. What they really meant is we're going to traffic Africans from all over Africa to do our job for cheap, not contribute to any growth into your country, but we are going to benefit from this. So they identify that narrative and really go with it. And then now the collaboration between the government and the tech company becomes very dangerous. This is now from experience for people who are looking to go into litigation in this area. I have never received a phone call from Facebook telling me, oh my God, you need to withdraw the case or we are going to hack your accounts. When we filed the case, that was what people would say, look, you should be scared, like WhatsApp is going to be hacked. I've never received a phone call from Facebook to that extent, but I have received several phone calls from the government of Kenya telling me, withdraw the case or else, several times. So that collaboration is what becomes very dangerous because accountability and the people who call out these companies become enemies of the state. So they don't need to lift a finger. The authoritarian tech company does not need to lift a finger. It just needs to rely on the system it has set up. After we filed the case, there was, I think, a record of 6 times that Facebook officials were flown to State House. And when we secured a win at the Court of Appeal that actually Facebook can be held accountable in Kenya, the government proposed a law that said, actually, you cannot sue tech companies in Kenya to just walk back that progress. So you have to appreciate the threat and the challenge before you for what it is that this is a tech company that is very keen on not being held accountable, that is going to partner with a government that is not keen on being held accountable either, and now you have a complex problem. This is not to say that it's not impenetrable, and for sure we have made steps, and we are clawing slowly and dismantling that, but I'm sure we'll have a chance to talk about those interventions. But to just dampen the mood a little bit, this is the fight that we are facing.
And thank you, Mercy. And now maybe we can turn to Mandi to talk about how we can how we can challenge this collusion between tech companies and states in host jurisdictions through litigation. Why host state litigation?
Thank you so much. I don't know if this is on. Let me just use yours. Thank you so much, Gabrielle, and thank you to the previous speakers, and thank you for all of you for being here. So I think I just want to paint a picture of a number of factors that we need to consider, right? We've heard from Tawanda the tech feudalism aspect, right? We all have on our phones. We all have these companies on our phones, right? We have these companies on our phones in our countries. We are here in Namibia, right? A lot of us came from Zimbabwe, South Africa, Liberia, Senegal, Ghana, Nigeria, right? And second fact I want to show, we've also heard that there are about 5 or 6 companies that essentially run the global tech world, right? None of those companies recognize themselves as African. None of those companies say we are from Nigeria or we are from Kenya or we are this, right? Third factor is we've also heard from Mercy the reality that our use of these platforms doesn't stay online. It affects us in a very physical way, in person, where we find ourselves in our countries. Yeah? We accept that, right? That the harm that comes from that, the trafficking that Mercy is talking about, the harms in the Meta case that we're involved in. In the Meta case that we're involved in, it was an online provision of information and data about someone's father that led to his father being killed, right? People communicated and organized on a platform. The other case, one person is not able to ever travel back to their home country because they were identified in a particular problematic way on a platform online. And that had real consequences in his day-to-day life for his family, right? So we know that the harms don't stay on Facebook, on your phone, locked away, that you could just cloak your phone and move on and the harm stays behind. It follows you wherever you are, right? And then within that framework, the other factor to consider is all of our constitutions give us rights. You have a right to safety, you have a right to equality, you have a right to freedom of expression, you have a right to this, you have a right to that, right? And in all our courts, in all our countries, we all have courts. The level of functionality, the level of boldness, the level of diligence, different. But we all have a Ministry of Justice, we all have a Chief Justice, we all have courts, yeah? Anything I've said so far that any of you disagree is present in our lives? You can say yes or no, right? So, right, we put that sort of framework of our existence on these platforms. We think about the power that is being put around. This is what you can use, but while at the same time controlling how many of these platforms can come out. Right? There's so many, there are platforms, there are options, but there are not that many options. Not as much as you can choose shoes, right? There are many more options. So now what happens when you now have to grapple with these harms and violations of your human rights in your country, using this platform in your country by a company that's going to come and say, sorry, your constitution means nothing to us, your courts means nothing to us, come sue, you signed a contract. When you agreed to that thing that says agree or disagree, I'm a lawyer, but I can tell you I've never really been like, okay, let's read these lines and see before I said agree. Why? Because I'm trying to quickly speak to someone and it's telling me you need to update to use it, and I update quickly, right? So now, you've now suffered these harms. Then they say to you, sorry, your courts don't matter to us, your constitution don't matter to us, because you agreed to a contract by clicking agree. And in that contract, there's a clause that says you must only sue us. For Meta, it says you must only sue us in California, and I think it's Santa Clarita, one of those, right? So that's where you must sue us. What is the reality of that then for you? Again, you're doing all of this in your country there's a court system, you've got all of these rights. What does that mean then for you? Right. I want to pin that in there and go to what is home and host state, the difference between the two. Home states, generally, generally in litigation is the country where a company is registered. A home state of a country is the country in which they've got their papers signed and they're registered. So for most of these 5 countries that I've mentioned, 5 companies that I've mentioned, most of them, it's either US or Ireland, right? Generally. That's where they've got their papers of incorporation. They went and filed an application form and got the name registered for what, as an, PTY Limited or whatever it is. Host states is the countries that host the companies in their country, where you allow the platform to be accessed in your country without the company necessarily being incorporated by the laws of your country. So most of our countries here, right, unless there are people that are American or Irish, most of our countries here are host states. Meaning, if you ever want to then seek accountability, and naturally, we all want to go to court. Your rights are violated, the law tells you that you've got a right to effective remedy. In fact, it is a principle of customary international law that for every violation of human rights, there has to be an accompanying remedy, right? And this includes reparations, compensation, guarantees of non-repetition, and so forth and so forth. So all of that means nothing because the company is going to say, we are not Kenyan, we are not Namibian, we are not South African, so you can't sue us in your country, your laws don't apply to us. How then do we accept that? Because it's the same as the feudalism lord who said, well, in this you must work 12 hours. If you want to stay, you must work 12 hours, otherwise you must leave. But you don't have anywhere else to go because the platforms are part of how we communicate. Remember the access that we all keep wanting, internet access, we all want to WhatsApp, want to put a cute picture of ourselves, as we should, right? Because we all look good, so we should, right? But it comes with you're giving up something. You're giving up your whole part, we talk about separation of power. You're giving up your judiciary. You're giving up your access to accountability and justice. So how do we then, how do we live with it? Do we as Africans accept that if we want justice and accountability from these platforms, we have to first apply for a visa, then travel to the US, find a lawyer who's going to be able to take, and let's not forget the money. We must have the money to get the visa, to travel, to get the lawyer to brief, and it's not gonna be like a 2-week thing where you quickly pop over there and do your litigation, come back. It's years in litigation. And guess what? In the United States, there's also a law in the United States that also says you can't sue platforms because they're not publishers. So you can only sue them if they're considered to be a publisher. So if you post on Facebook, Meta is not considered to be a publisher, right? Because they're not the ones that publish the words. So you really are unlikely to sue them successfully in their home country. So what does that mean then? There is unchecked power and there is no accountability or justice. So this is why for us, we think that it's important for host states to read how they establish jurisdiction and standing in their countries in a way that also reflects or relates to the realities of using technology. Because how can a company say, I'm not before this country, yet you've got millions and millions of users? Number one. Number two, there's also money. You're making profits from those users in the country. You're making money from marketing to those users in the country. How then can you say you're not in Kenya, you're not in Swaziland, you're not in this, you're not in that? How can you say that? How can you make the argument? How then as host countries do we need to think about presence to establish jurisdiction, to enable the courts? Some countries, like Kenya, for example, has a clause that talks about if you violate Kenyan rights in Kenya, the court has power to hear your case, because the courts are vested with the power to address any human rights violations from any rights protected by the Constitution of Kenya. So that's one example. The other example is that we have to really think practically about how we say a court can find jurisdiction. And as we are moving towards governance of technology, governance of platform, it needs to also move with the governance of accountability, right? Because we're moving so much towards governance and thinking about regulation, advertising, and all of that, but we're leaving our courts behind. because our courts are still thinking of jurisdiction in the presence that you have to have been registered here. So we need to also motivate our countries to start improving how jurisdiction of tech is done. And also for countries that are also in constitutional law, in constitutional reforms, it's important to start also putting these clauses in the constitutions to say that no matter who you are, if you violate rights in this country, courts of this country have jurisdiction. Otherwise, our engagement and participation, as Tawanda explained it, means that we really give up the judiciary. And we really give up accountability, and importantly, we give up our ability to get effective remedies for rights violations. And I don't know for you, but for me, it's not a world that I want. I want to be able to know that I have these rights, I can enjoy them. And if someone hinders my ability to enjoy them, I want to be able to know that I can go to court and not worry about whether I can actually go to court and maybe worry about, do I have money to not pay a lawyer? Do I have money to carry this on? So I think we have to really take that seriously as host states. And yesterday there was a conversation around how the AU can also be brought into this and take a position, take a sort of group position around it. And I think that's also an additional step that must be taken in parallel. But in reality, we need to be acting ourselves to say, if I'm using a platform in South Africa, if I'm using a platform here right now in Namibia, and my rights are violated, I shouldn't have to accept that I'm just going to have to give it up and not have accountability because I'm using a platform that is not created or identifies as Namibian. Thank you very much.
Thank you, Mandi. And I think now is actually a good time to go to you, Nora, who's going to talk about the practical experience of litigating, challenging this jurisdiction in countries like Kenya and other countries from your experience.
Yeah, thank you. And yeah, it is an interesting point to come in when others have spoken so clearly about, I think, some of the crucial issues around this topic, right? And I think the things that I would like to highlight specifically are the challenges and the opportunities that we find in litigating against these companies in the host countries, as you said, and using the example of the Meta case. And I think probably everyone in the room here is familiar with it, but just to remind ourselves also, and I think that is something that at times, at least for me, it can get lost in all of this and all the considerations we're having around this, right? So the case around algorithmic discrimination relates to the first petitioners, a man named Abram, whose father was killed by a violent mob outside his own home using the same language that was previously posted on his Facebook page that had not been removed, despite the family attempting to get it removed. We have the petitioner, Fiseha, the second petitioner, who's also who's also been harassed for the research he had been doing, working as an Amnesty researcher on Ethiopia as well. And then Katiba Institute has come in around the constitutional issues that apply in Kenya around this case. And then obviously, as Mercy has touched on, there are also the labor cases where, as she said, there's, so many people who are suffering PTSD, who are suffering from severe mental anguish just due to what they've been exposed to. And in both those instances, what we very clearly see is that this is a choice, right? This is a decision that the company is making to allow these things to happen. We're not saying that the company can prevent all hate speech at all times, always, but we have seen that Meta is able to limit that kind of spread of hate speech, that they are able to take action against that, and that they have done so in other jurisdictions, that they have done so in the US when they chose not to do so in Ethiopia, when they've chosen not to do so in the context of Myanmar, when they've chosen not to do so in a number of contexts in the Global South. Similarly, with content moderation, we know that, again, in multiple contexts, people are exposed to terrible content and have to work on terrible content in order for there to be, a way for us to address this, right? There are people working on rape cases of children who have to look at evidence and who have to deal with that. But there are processes. There are processes for how people are meant to be dealing with that, right? They're meant to be, they're meant to receive psychological treatment. They're meant to receive support. They're not meant to be looking at things for, you know, seconds, then make a decision, then move on to the next thing, look at it again. Like so there are ways to deal with this, but the company is choosing not to do that, right? They don't want to throw more money at it. They don't want to invest more time, more effort. Ultimately, I think, as Mercy said on another panel yesterday, it's about their bottom line for them, right? It's about it's about what it comes down to business-wise, and so I think a really relevant thing in saying what are the opportunities in litigation in the Global South against this is we are bringing those cases home. We're bringing accountability home. Yes, it's not the home country of the company, but it is actually where a lot of the harm sits. Now, I don't want to discount that there is real harm in the home countries of those companies as well, right? We have all heard about instances of, for example, young people killing themselves because of content that they're exposed to on these websites, etc. But again, I think a real crucial difference is the choice in actively deciding not to address this issue in our countries, not to address this issue anywhere on the African continent, while happily exploiting our data, while happily exploiting our workers, happily exploiting the tax loopholes that they can find, or when there's not a loophole, just not paying the tax. So, you know, I think bringing that accountability home and being able to stand up in our own courts, in our own jurisdictions to speak to these issues is a crucial piece here. I think another benefit, and one that is frequently underestimated, and it drives me up the wall when you look at how frequently judges or lawyers in their pleadings will cite, cases from the global north, will cross-cite to other cases from the global south, and how rarely you see the thing working the other way around, right? At the same time, we actually have a lot of progressive jurisprudence coming out of our courts. So that is another real opportunity. Our judges are actually ready to say, let's take this on. We see what the problem is. Let's look at this. And they're ready to say that because, again, not only do we have progressive jurisprudence, we also have progressive laws. Kenya's constitution, for example, is relatively new. It's a teenage constitution, and it provides, when it comes to public interest litigation, it provides for really great opportunities to say, yes, we can hold people accountable for the damage that they're doing on behalf of the public. So we are able to bring cases with less of a cost risk, for example, when it's in the public interest. We're able to bring cases where there is a clear risk of a violation. We are able to have standing as Katiba Institute. Many jurisdictions in which I've previously worked in, we would not be able to go to court as an institution, right? We're able to do that in Kenya. So I think, again, as well, from the opportunities perspective, there are laws, and I think yesterday there were quite a few conversations about the lacking regulations on the continent around certain types of emerging technologies. And I agree that it would be valuable to have more regulation, but at the same time, I think we shouldn't underestimate the laws we already have. We can use those laws. People are violating our fundamental rights. I actually don't need a regulation to tell me that you being responsible for my father dying, you need to be held to account for that. I don't need a specific regulation on content moderation to tell me that. So I think we also need to really, go back and look at, like, what are our fundamental rights, what are our laws that we already have, and how can we use those. Emerging technologies are also not some kind of big mysterious thing. They still are in our universe and in our world as it works now. So I think there are real opportunities and real benefits to bringing these cases in our courts. At the same time, there are also real challenges, and I think Mercy already touched on some of them in terms of when she spoke, for example, about how, the way Meta picked up and moved away, right? As soon as they were supposed to be held accountable for some of the labor rights violations. And I think therefore it's so great the work that she's doing with the Oversight Lab to say, let's tackle this in multiple places, right? Because what we need to stop doing is have this game of whack-a-mole where we're trying to hold a company to account in one place and then in another place and then in another place without that being coordinated and a coordinated effort. Because the company is actually doing it as a coordinated effort. The company is saying, you don't have jurisdiction over me because you're just a host state. Oh, well, but in the US, yes, here you do have jurisdiction, but yes, there's that law whereby you can also not hold me to account, you know? In Ireland, there's another, so it keeps going like that. It turns out that when you look at it overall, it's not that Meta is actually saying, oh, you can't hold me to account in Kenya, but if you can find another reason, you know, to sue me elsewhere, then please go ahead. No, somehow it seems they are above the law, beyond the law, globally. So it's really important that we look at this cohesively and address that sort of from a global perspective. So that, I think, is one of the challenges, is how do we grasp these companies that don't, you know, that aren't at home in our own countries. This really ties closely to implementation as well. How do we actually get them to abide by any kind of ruling when they can just pick up and go away? That same implementation piece relates again really closely to what has been said about techno-feudalism and the way in which they're working with authoritarian governments, right? So our own governments are another challenge in bringing this litigation, because we must ask ourselves, to what extent can these cases be implemented? To what extent can these cases really be brought? And then finally, I think one other point to make is that we must also not underestimate strategic litigation against public participation in this context, right? These companies have so much money, and they are happy to bring slap suits and to tie us up in ages and ages and ages of either procedural delays or again to actively go forth. And I, like at Katiba Institute, we're currently representing a journalist who's facing a slap suit from Safaricom, our own telecommunications provider in Kenya. So the tech companies and the ways in which they're willing to go ahead on this, and in that, by the way, they have learned from the climate space, right? They have learned from how big companies have been working in that sector, and so I think, as people working in the tech space, we actually must also really collaborate with people from the climate space. We must learn from each other. It's a lot of similarities, both in terms of how we work with experts and how we can counter some of these things. But I think the really crucial piece to take out of these challenges and out of the opportunities is really the solidarity. If we can, so many people at this conference are from different jurisdictions on the continent. Can we work together? Can we say, let's, even if, of course, I'm not a lawyer in, say, Nigeria. I can't go to court in Nigeria. But can we make sure our cases are aligned? Can we make sure our efforts are aligned? Can we have that solidarity amongst also the people that we're representing to highlight, at minimum? I think there are real difficulties in holding emergent technologies and the way in which technology also develops to account before something as slow and traditional, for lack of a better word, as a court. But there is the court of public opinion. So can we make sure that we highlight these things in all our places? Can we take these stories back and can we say, okay, yeah, how can we collaborate on this? I think that is really where ultimately our win will lie.
Thanks. Hello. Thanks, Nora, for that. A really comprehensive overview of how we can challenge these companies in Kenya and in global South jurisdictions, and the importance of solidarity and pushing the narrative on the ground to challenge some of the narratives that big tech is pushing by way and controlling using their algorithms. We do have 2 questions that have come in through the app, but I now want to, before going to those, I'm wondering if there's any live questions that any members of the audience want to ask to the panelists on any of what's been discussed so far. If you just introduce yourself and then ask your question.
All right. Hi, my name is Charlene. I'm from Amnesty Kenya. And I was, first of all, thank you so much for setting such a, I guess, grim picture of what the cases look like right now. And I was wondering if there is a model case that has been used to successfully hold these platforms accountable, especially in Africa. And then I think my second remark is to really wish you the best in the Meta case, because I feel like it sets a good precedent with how we handle, you know, cases against the atrocities technology companies perform in Africa. Yeah, that's all.
Should we just get like a couple?
Thank you, Brian Birohanga from Sipesa. So I want to contribute, but also ask a question. So there was a complaint in Uganda by a couple of Ugandans in November alleging that Google had failed to register as a data collector and that it was unlawful. They had unlawfully transferred data outside Uganda. So Google's defense was that Google admitted it's not registered, and it admitted it's not registered as a data collector, and it claimed that it was exempt, that it shouldn't register. And accordingly, it pointed out that its global privacy policy to claim it met accountability standards basing on its own policy, kind of like what you just explained. And I also wanted to contribute to like what the analogy of techno-feudalism. And my question has disappeared. It's coming. So if global platforms operate like digital lords, extracting data, dictating foreign law and refusing accountability, aren't we already living in some kind of techno-feudalism? The question is, how can African states or civil society, what can we do to avoid being reduced to digital slaves and build some kind of sovereignty to regulate these platforms on our own terms?
Thanks. Do we have any more? Yeah.
Thank you. I just want to know, like, in terms of, because we are highlighting the limitation of litigation in holding these institutions accountable at domestic level, and how it is also very difficult to enforce some of those judgments with domestic courts. I'm wondering, like, don't we have like some of the institutions at the regional or international level? I just want to know how does it play out. But I'm also thinking, like, isn't it this an issue of investing more on policy or advocacy as opposed to litigation? I was also thinking when you said you also want to sort of like control the narratives with the court of public opinion. And I'm also grappling on how do you reframe the message so that it resonates with the people on the ground, because there are a lot of gains that we are seeing in terms of using these platforms, you know, to sort of like hold the governments accountable. So just want to know how it will play out.
Thanks. Some good questions there. Who wants to start?
I'm holding the mic, so
Yeah.
I can start. Okay, so to your question, first of all, thank you so much. I think we all believe this is not a sprint, it's a marathon. So we had budgeted for a 6-year litigation. I mean, if it gets to 6 years and we've not made progress, then we're going to be worried, right? So to your question about whether there have been good examples, there have been instances of good examples, and one of them is the cases themselves, but I'll come to that in a second. It's good to pay attention to what's happening in South Africa. The approach is quite different because it's the administrative regulators who are actually coming up and wanting to take space. I got very impressed, for example, by the data protection and access to, I'm butchering the name, so do not quote me, but the data commissioner invoking inherent jurisdiction over Facebook to challenge the WhatsApp terms and then making it Facebook's fight for them to come and say, actually, you don't have jurisdiction over us, let's go to court. Those are good examples. But one thing that has happened in Kenya that we have to take as a signal to light other fires elsewhere is what Mandi spoke about, Section 230, the immunity that these tech companies enjoy in the US. And in the EU, the administrative processes there are not perfect. So you see the way in which, in the end, the administrative fines also offer them immunity because they can budget for them and they can get away with that. It's not true accountability. So when we went to court in the Abraham Fisher and Katiba case on the algorithm, the argument came up about this immunity conversation because in the US, literally last year, the Supreme Court held no matter the role Google played in radicalizing a young person because of bombarding them with terrorist content, and even Meta, because it was 2 cases at the Supreme Court, just on the algorithm, how the algorithms are spurring harmful conduct because you're oversaturating people with harmful content. And the Supreme Court said, even if this argument made sense, still Section 230 absolves them from any liability, so we cannot hold them accountable. In Kenya, the judge got an opportunity to say, we do not care. Where is the human in all of this? The human being was harmed. The human being, one is dead, one has been displaced from his family, one cannot go back to their country, the Kenyans are at risk. That is what we care about. What we have in our continent is constitutions that prioritize human rights law. And that prioritization is important because it gets to bypass all common law rules, all tort rules, all nonsense about liability and product liability and consumer protection, and just ask the most important question, what about the people? What are they going through? That in itself is the first time that that approach has been applied anywhere, and we really need to capitalize on that because we're not deluded that Meta is going to take it lying down. Of course, they've gone to the Court of Appeal, they go to the Supreme Court. If that were to be overturned in the next 4 years, at least in those 4 years, let us see other people taking advantage of that and convincing their courts that, by the way, this has already happened in Kenya. We should be seeing multiple suits like popping up everywhere. And then I won't answer all of them, just 2 I think that I think I could speak to. It's to say it's difficult, but it's not impossible. It's difficult, but it's not impossible. But we also have to be very aware of the fight that we currently have on our table. I think the biggest disservice we could do for ourselves is underestimate the opponent that we are coming up against and underestimating the risk, the level of risk that we are operating under. It's as simple as the cases could disappear if your clients were put at risk, which we have seen with our clients being threatened with deportation, or even the lawyers themselves. Like, we operate in very funny jurisdictions where things could happen to the lawyers. And 2 of the things I have said I'm going to just use my time to crusade on is, 1, as human rights defenders, as advocates, as lawyers who are taking up these cases, we have to root ourselves in communities. And I'll give the example of the ride-hailing sector. Across the board, you see how powerful the ride-hailing sector is, and that is because the issues come from the drivers themselves. So they have become a formidable force because it's the drivers that speak up about the issues. We have the disadvantage in this field in that the activists who went to school to educate themselves are the ones who know more about the issues than the communities. The communities know this thing affected us, but they don't have the language. So we have to go back to the drawing board and involve communities. If you're representing communities that have, indigenous communities that have been excluded, even representing communities that have been harmed by algorithms, you have to go back and get their buy-in and get them to be the surrogates for the message. You fight your battles in court and in advocacy and in legislative processes, but let them be the mouthpieces, because security-wise also they are who is going to hold you. Like, if you get arrested, they're the people who are making noise for you. They're also your shield in times of conflict. And then the final one, which is what I'm hoping that we leave this room with, light little fires everywhere all the time. This is the only way we win this battle. It's not a Kenyan thing, it's not a South African thing. It literally needs to be every single country on the African continent, because we're all going through the exact same experience. I'm glad he shared about Uganda, because what is that language? Exempt, we're exempt. I'm sure your act does not have any exempted categories, right? It's another way of introducing immunity conversations. But what I always say is that, well, you can claim you can claim you are God, doesn't make you God, but like you can claim you're immune, doesn't make you immune. So we literally have to coordinate in all our different jurisdictions, in all our different lived experiences. We're all getting discriminated against by the algorithm. We're all getting harmed by the algorithm. There isn't a single African country that has gone through elections and not gone through some form of post-election disturbances or violence that has been instigated on Facebook. All of us have exact same experiences. We have to light these little fires because that is the exact same strategy they're using. He said here about divide and conquer. He said here again about making sure that you've kept people at the same level. Okay, we can respond with the exact same coordination. We can respond with the exact same level of vigor, because that's the only way we win against the tech companies.
Thank you, Messi.
So I just want to touch on the question. I didn't get your name, sir. I think it's such an important question, right? Around when do we go to court and when do we not go to court, and why do we go? So I think for me, the most important thing to remember about strategic litigation is that it's not a tool that stands on its own. It never does. It never does, and it never will. Strategic litigation is most effective if it's connected to an effective policy framework, legislative framework, advocacy framework, research, and campaigning, right? And so you may win in court, but if the policy does not get addressed on who can actually sue in this country, who can be sued in this country, you're not going to succeed. Or even if you change the policy that says who can sue and you can be sued as long as your rights were violated in that country, but there's no research to back up what the harms are in order for you to present them as evidence, you will fail, right? If there's also no campaign that makes it clear that we won't stand down and just be, I like the terminology that you used about being digital slaves. If we're also not campaigning and sending clear messages as human beings, that we're human, we've got rights, and we're going to stand for them, litigation sometimes also doesn't succeed. So for me, I think it's important to understand the mutual connection that exists with all of the different works that happens. So if you don't even have the community members understanding their rights, understanding what's a violation and what shouldn't happen, you don't have litigation. Because who are you litigating for? The people who are harmed must be able to know that I'm being harmed. They may not have the language of explaining the algorithm did this and then it amplified. They may not have the language, but they have the language of harm. They have the language of humanity. They have the language of existence. So all of that for me are in this mutually beneficial, mutually connected, and mutually serving relationship that if the courts are not functioning, Parliament also doesn't function well in the executive, as well as the human beings in the corner of it. So for me, that's what I just wanted to explain, that I think it's not an either or for me. It needs to really be, we want to take every tool at our disposal to really kind of throw something that's going to stick in order to start progressing. Thank you.
Yeah, thanks. Just to agree, I fully agree. It's not an either or on the policy and advocacy versus litigation, and we want to do both when we're talking about forward-looking. But I think the other important piece to think about with litigation is also the backward-facing accountability piece, right? It's really inspiring that we are speaking about clients who have an interest in seeing change going forward as well, and who want to see that these cases have a lasting impact in that way. But actually, it's also, again, just about the accountability for the harm that they have suffered, and that's where litigation does become an important piece that advocacy and sort of policy can't address in that same way. So I really agree that it needs to all go alongside each other. I also think on the question of sort of what can we do on the African continent and equally sort of how our international institutions, what's their role in all of this? I think this really relates back again to the regulations question and to the policy question. There are actually a lot of things that could be done on the African continent that would be really relevant to these things. And one thing I think that is crucial, it is not my passion. In fact, when I went through those classes in law school, I may have skipped a few, but antitrust laws, when it comes to these corporations, if we could have, as this is something that is being discussed more on this continent, if that can be something that is really taken up in this context, I think it would be incredibly valuable. The ways in which these companies are operating globally, but also in our domestic contexts, antitrust laws are going to be incredibly relevant, and so antitrust regulation is incredibly relevant. I also think to your question about public opinion and how does one shift that on the ground, given what the companies are also doing for us in say, how we're able to express ourselves, I think we shouldn't underestimate that people are able to see the positive in something or appreciate something, but also yet really see the harm that it's causing. And I think that companies frequently underestimate how quickly a mood can shift when they portray themselves in a certain way, right? It's really interesting, actually, to see how the language from many of these big tech companies has changed over time, right? They were the saviors. They were all doing good. They just wanted to, connect us. They wanted to, and now suddenly, they no longer care about that. So, and I think people are seeing that. People are picking up on that. It doesn't prevent us from wanting to use TikTok, X, whatever, to express our opinions, to also challenge our governments where we can. But again, I think we are not in a position where people aren't willing or able to shift their mind when they see the harm that is happening. And I want to give one concrete example there. Again, I touched earlier already on Safaricom as a big telecommunications provider in Kenya and moving into the region as well, who were seen, who are real point of pride for Kenyans for a really long time, right? Safaricom, really great. It has come up with M-Pesa. It's really like, we as Kenyans, how great that we have this corporation that, is something to be proud of. And recently, as we have seen how they have undermined us in protests, how they are surveilling us, how they're giving our data out to those who want to do us harm, there has been a shift in the mood towards Safaricom, right? So I think we see that. We can see a shift in the mood towards Meta. We can see a shift in the mood towards X to others. I think, again, it's just about highlighting, and I think that's really, again, speaks to what Mercy was saying in terms of let the people who are harmed by this come out and say how they're experiencing this harm, because people will listen. And then once they listen, that's when I think that shift can really come.
Thanks. Thanks, Nora. I think I'll just dive deeper on the question about us being, digital slaves. That's actually the term that I'll use, Brian, and thanks for saying that. I think we need to first understand and accept that we have been, I think our minds have been fixed in certain things, where if it is an African who is pitching an African platform to an African businessman, the probability of them being accepted is actually harder, okay? We are also like colonized in our minds. I have been in space, and I think Brian as well, where we have actually spoken about the different types of innovations, et cetera, and the response is we are not technical enough, okay? And take note, technical enough based on nothing but just us like seeing each other on a Zoom call, okay? There is no exercise, there is no test, etc. So we've also found in places where somebody can come from the West and pitches the same idea that somebody has pitched in Africa, and the tender does not go to an African. It actually goes outward, to the West. So I think the first thing for us is actually to decolonize our minds in terms of that. Like we have thought that tech is not a tech thing if it is not built by the West. I think that's one. Then we are dependent. I think there are so many memes, I think that you've seen, of people are like on screens. There are so many of them. And if there's a thing that I'm always trying to motivate people is that, are we actually aware of the things that we are using online and what is happening behind the scenes? So trainings and literacy, etc., are the thing. Then I appreciate that in digital rights spaces, we are now having people like yourself, like the lawyers, the people that, because sometimes I also feel that us as digital rights activists, we are highlighting the problems, but we then don't know the what next, okay? So because we are speaking together as activists. So having lawyers in the room as well, as a partner, and a constant partner as well, it actually then is an option. Because we always are looking at the cost to say, I don't think we can take this to court. We don't have a lawyer. And once we think a lawyer is involved, then there's a cost issue. Then we just say, okay, let's just go to the streets. I think the last thing that I just want to ask as well, it was then mentioned here, issues of solidarity. I think this is also a new buzzword. How does it actually practically look like? Because I feel like we are also selling a facade that we are in solidarity. We are building something in solidarity. But practically, when things are actually happening, like for example, I've learned a lot today. If I ask someone in the room, did you know about these cases? Most of us who are in the digital rights space and documenting these things might say, no, we actually don't. So are we saying Kenyans are only speaking to Kenyans virtually? Or is the Zimbabwean also very invested in that? And how are we building the network? I think those are the things that can then release us, from being thing. And localization, I think, localization of the languages of the apps, themselves. I do appreciate that we have the localization lab, but also they still need local actors to then change, the different English, French, etc., to basic language like Shona, Ndebele, Zulu as well, for the community that we serve to fully then understand how to use the platform. Thanks.
Thanks, you, Tawanda. I think we have one more question at the back. You still want to ask it? Yeah. And then, are there any more questions? Because I think this might be the last round.
It's just a comment. Hi, everyone. John Okande here from UNESCO, and thanks for the very insightful comments and insights. I missed a little bit of the first part. And I think a few wins that we can, these are just my thoughts, and what we also see is that Africa is talking about these things. But then one unfortunate thing is, of course, within our context, I can speak for Kenya, for example, we see, I think, we want to believe it's by design, regulatory dissonance, where you have different regulators that do not have a mechanism to speak to each other or work together and support the noble work that Mercy and others are doing. And governments performative. There is a marketing concept around that. They call it performative governance, where they will show that they're doing something, and basically they're not doing anything. And we see this being mirrored both by platforms, but also by our governments. And you'll find civil society and other actors really putting in resources and trying to rally people. But the sad thing is, if governments do not listen, nothing is being done. And we are seeing this in different contexts. For example, in Kenya, I follow closely Mercy and others. And when there was, I think, a bill mooted on the labor issues, the same government working to ensure that it's completely weakened because of the incentives probably they get. I just want to see how, from where you sit, how can government action be triggered, particularly in very critical human rights linked elements, that they just decide by design that what they do or what they get is bigger than the core human rights things, because we see it vis-a-vis platform capitalism. I know the next thing, what is ongoing right now is on data. And within our context, we know the data agenda is being run differently. I don't want to name names, but our governments are sitting aback. I've been attending several discussions here. I had a meeting today with colleagues at the UN, and one thing that comes out that we speak to each other, but government is missing. And is it by design that they don't want to be part and parcel of this? How can they be brought on board? Because you will push all these things. It's noble, but at the end of the day, it's the government working against you, because you make progress, you go back, you make because legislative instruments are weakened, they can't respond. If, let's say in Kenya, ODPC does not have enough money, or the judiciary does not have enough money, you will not do much. And you're fighting a war with platforms that have so much disposable money. So I'm just curious, how can we nudge government? Because on certain human rights elements, government has been nudged to come on table. How bad can we be to bring them on table? Thank you.
Thanks. Thank you. One more question.
Thanks. I just had a question in more of a follow-up of what is just said. How can we drive this conversation to a point that Africa stops being an attachment to other regions? I want, because I feel like we need to drive conversation whereby we're not part of the global terms and condition, and for us it's just a tick exercise and there's nothing we can do to actually change that. Is there an opportunity for us to rally this? It becomes an African conversation. We're not just part of EMEA, and the A in EMEA is just there for, but just as a beautiful addition for the sake of it. Because that's where the conversation, I think, we're struggling with, because it becomes very hard to push for the terms and condition and changes. Yeah, it will apply for Kenya, but then there's another whole country that they're still being affected and they do not have the muscle and voice to speak up, because digital literacy is a very big issue, and some of them don't even know how to start addressing this, but they're still using the tool. So how can we drive this conversation to a point, the way they do policies in EU and America, which are very different because of how the nations are and the regulators hold them accountable? How can we drive this conversation to ensure policies, that their global terms and also global policies are very specific to the African market?
Thank you. So we have two good questions there about how to make this specific to the African context and also ensure government buy-in. Maybe if we can just do the online questions, and then we really have to wrap up. The online questions were, how can we use strategic litigation in contexts where there is not a strong regulatory framework and strong laws domestically? And the other question, I'm paraphrasing because I can't find it, is if these companies are saying that they're not responsible for content, but we know that they're responsible for the algorithms, how can we use, why aren't we challenging the algorithms in litigation, or are we?
Just quickly, because I know we're out of time, triggering government action, is it a nudge or a force? Are we nudging the government to do its job, or are we forcing the government to do its job? The difference here is on why the government is not doing its job. The Kenyan example you cited, the court has said that you can sue Meta in the country. Government goes to make a bill that says you cannot sue Meta in the country, because the government wants to keep a political promise of pumping jobs, no matter what they are. So no matter how much nudging you do there's no nudging that is going to force the government to do its job. So it's going to be forcing the government to do its job, which is why also, like as the Oversight Lab, we took that bill to court, because it was passed again without consulting people. They did not do public participation on the bill. So it depends. If the issue is a capacity gap, because also okay. So okay. So if the issue is just that the government does not understand the issues that are at play, then it's a capacity problem. Then you build capacity and nudge. But if it's just difference in interest, then you have to force it through litigation or other measures. Thank you.
Thank you, everyone, for all of your questions and comments. This is an ongoing conversation, and we'll be around. So if there are any questions that we didn't get to answer, just come and find us around the conference center. But we're really, really grateful that you came to this panel discussion, and we hope to keep this conversation going. Thank you.